You've heard me say before that debt collection lawyers are the lowest form of life in the judicial ecosystem. We have a good ruling on that in Florida. Hi, folks. Tony DeWitt again with another video on the law. Remember, I don't dispense legal advice here, and this is what we're talking about today. This is the case of Cheryl Glover as an individual versus the Ocwen Loan Servicing Company. Now, for some reason, and I don't understand exactly why, there are certain banks and mortgage granting institutions that do not collect their own money. They use loan servicers to collect the money and send it in to them, usually by electronic transfer. But how those people go about obtaining the funds is sometimes it's very much like collecting an overdue debt, like a credit card debt would be. And as a result of that, these people fall under the Fair Debt Collection Practices Act. What we have here today is a different sort of issue because it deals with something that many of you may be familiar with called convenience fees. So let's dive into the opinion and take a look. This consolidated appeal requires us to decide whether defendant appellant Ocwen Loan Servicing violated the Fair Debt Collection Practices Act when it charged consumers optional fees by making expedited mortgage payments online or by phone. Plaintiffs allege that these speed pay fees were an unconscionable means of collecting a debt under the Fair Debt Collection Practices Act, which prohibits collection of any amount, including any interest, fee, charge, or expense incidental to the principal obligation, unless such amount is expressly authorized by the agreement creating the debt or permitted by law. So you can have certain things that are permitted by law and permitted by contract. And if you have that in your contract, well, you can collect those fees. But if you don't, you can't do it. District courts in the 11th Circuit and around the country are split over whether the Fair Debt Collection Practices Act prohibits loan servicers from collecting these pay to pay instead of pay to pay, or convenience fees for use of certain payment methods. They went on to say, in this case, the district court held that it does violate the Fair Debt Collection Practices Act, and it awarded judgment to Glover and Booz. Most judges in the middle and southern districts of Florida have reached the opposite opinion, finding that the convenience fees were neither part of nor incidental to the transferred debt, but separate fees paid voluntarily for a separate service. When viewed in isolation, this conclusion has some merit, but it overlooks the broader context in which debt collection activities occur. Ocwen's convenience fees may have been optional, but it charged those fees to consumers who had no option but to do business with it. After careful review and with the benefit of oral argument, we hold that Ocwen violated the Fair Debt Collection Practices Act because its debt collector charged an amount that was not expressly authorized by the agreement creating the debt or permitted by law. We affirm the district court's judgment for Glover and Booz. Many of the federal courts in the South, and indeed many of the district courts of appeal in the South, tend to be more conservative than their northern brothers. And they also tend to be less consumer friendly. But one thing they certainly are, at least in this case, is people who read the statute and apply the clear terms of the statute. And that's what I think this opinion does best. So the court goes into the facts and says that this company acquired servicing rights because they defaulted on their mortgages. So they offered them an opportunity to make expedited payments over the phone for prices ranging from $7.50 to $12. Ocwen did not charge a fee for mailed payments. The payment processing company, SpeedPay, kept 40 cents of each fee. Ocwen kept the remainder. Neither of their mortgages nor promissory notes mentioned fees for making payments online or by phone. And what's interesting here is when you look at it, if you got a $7.50 fee and the servicing company keeps 40 cents of it, and this Ocwen company keeps $7.10 of it, you can tell this is in the area of a gouge as opposed to a convenience fee. So, Boozer and Glove filed nearly identical actions in Florida, and they alleged these fees were unlawful under the act. The parties agreed to consolidate their cases and submitted both for judgment on joint stipulated facts in lieu of a bench trial. The court entered judgment for both plaintiffs, holding that one, Aquin was a debt collector, two, the speed pay fees were expenses incidental to the principal obligation and are covered by the Fair Debt Collection Practices Act, and three, speed pay fees are not permitted by law nor expressly authorized by the debt agreements. And it awarded them actual damages. Aquin timely appealed, and here we are. So, because it's on a stipulated record, there really is no fact to have to they have to parse or look at any testimony or anything like that. So there's no objections to any of the evidentiary material. They can go and look at the legal conclusions offered by the district court. So they go back and they look a little bit at the history of the Fair Debt Collection Practices Act. They go into the history and they talk about disruptive dinner time calls and downright deceit, among other things. That's why they enacted the Fair Debt Collection Practices Act. One of the things these debt collectors would frequently do is they would call somebody and say, "We're going to send the sheriff out to your house, and he's going to have an arrest warrant for you because you didn't pay your money." And that's theft. So you need to man up here and pay your debt. Otherwise, we're going to send you to jail. Well, there is no imprisonment for debt in the United States. Thank the founding fathers for that. They wrote that into the Constitution. So the whole idea that you would have somebody imprisoned for debt is pretty funny. But your average consumer doesn't know that. Several years ago, I talked to a woman who was in a state of near panic because she found that this person had called her and said, "Look, we're going to send you to jail. We're sending the sheriff out to your house in an hour if you don't call us and pay us." And of course, they were talking about a credit card payment for a fee. So I'm sure they were going to charge a fee on that too. The long and short of it is that with respect to throwing her in jail, they couldn't do that. That was an unauthorized practice under the Fair Debt Collection Practices Act. And I was able to, she was in a part of Missouri where I couldn't get to her, but I was able to get her into the hands of another attorney who handled that matter and took care of it for her and pretty much wiped out whatever debt was owing because they had treated her in this way. And you find this kind of thing happens frequently. People that get hired in collection agencies don't really understand the law. They're supposed to get trained for it, but instead what they're told is you'll get a big percentage of the recovery if you are able to get these payments in, and that's how they're compensated. That's how the collectors are compensated in many of these places. And as a result, they oftentimes do things to cross the line. The key thing about the Federal Debt Collection Practices Act is that it authorized private lawsuits and weighty fines designed to deter these kinds of collection practices. Abundant evidence of the use of abusive, deceptive, and unfair debt collection practices were found by Congress when they instituted this statute. And its purposes is to eliminate those abusive practices and to promote consistent state action to protect consumers against debt collection abuses. Unlike creditors who are generally restrained by the desire to protect the goodwill of their business when they're collecting past due accounts, independent collectors, these third tier agencies who do it for a percentage of the recovery, they don't have that same interest in protecting consumer relations. And so many times they go above and beyond what's right. So by imposing these affirmative requirements, they prohibited a range of debt collection practices, and one of those is using unconscionable means, which is what the court says the issue is here. Here's what the statute says: without limiting the general application of the foregoing, the following conduct is a violation of this section: the collection of any amount, including any interest, fee, charge, or expense incidental to the principal obligation unless such amount is expressly authorized by the agreement creating the debt or permitted by law. So, for example, if there was a fee that state law in some state authorized to be collected in order to get this done, well, that would be okay. It would be okay for that not to be an action under the Fair Debt Collection Practices Act. But otherwise, unless there's, strict law on the issue of collecting this particular fee or charge, then unless it is authorized by the agreement creating the debt, in this case, it was a mortgage obligation. So unless when they signed for that mortgage, it had this provision in it, they couldn't collect it under the Fair Debt Collection Practices Act. And it says interpret the act consistently with our obligation to construe consumer protection statutes broadly in favor of consumers. Now, I just have to tell you, not all district courts apply that rationale. And that's one of the reasons why the courts of appeals get so many of these, because it appears to the district courts, I guess, that people are using this act to weasel out of paying a debt. And I would agree that in some cases that's absolutely true. But you have to remember these third tier debt collectors are people who are going after debts that are 10, sometimes 15 years old, well beyond the statute of limitations. And they're relying on tricks in the law, like the fact that you don't come into court and challenge the debt, to establish their right to collect that debt. So, you know, in some areas, I can understand the concern of the district courts, but not in most, because usually when you are claiming under the Fair Debt Collection Practices Act, you have been abused by someone who did something like I was talking about earlier, where the lady was called and told she was going to get a visit from the sheriff and be sent to jail. So the statute provides a private right of action to any person who is harmed by a debt collector and who violates the act. The bottom line is just this: the 11th Circuit, which is Georgia, Florida, and Alabama, if you live in those three states, the, the Circuit Court of Appeals for those three states has interpreted the Fair Debt Collection Practices Act to bar the collection of convenience fees unless they were in your original loan or mortgage contract, or unless they are specifically authorized by state law. So if you get hit with those, you should contest them and refuse to pay them, and probably see somebody like an attorney who practices in this area about the possibility of a Fair Debt Collection Practices lawsuit, because even if you don't have any damage, even if you don't pay the fee, it's still an unconscionable act and you can get statutory, I believe it's called statutory penalties for it. So that's something that might be available to you. That's what I have for you today. Thank you so much for watching. Have a terrific day, and come on back and join me next time down here. Thanks for watching my video. If you have a request for me to cover a topic, please send me an email to the address above, and in the subject line put video request. If you have comments, drop them in the comments down below. If you found the content worthy, please consider subscribing. Since I started doing this work, I have always asked listeners to consider doing just one kind thing every day to make somebody else smile or make their life better in some way. Please consider doing that. It makes the world a better place. Now, YouTube has some suggestions for other videos of mine you may find interesting.